A recent question that we've gotten from one of our viewers, and thank you for the question, is can you raise self defense and also that you are not the wrongdoer or the shooter in a case? This is what I'll say. Your lawyer, the person who's living with the case, the person whose name is on the docket knows best. With that said, generally speaking, I cannot imagine a world in which I raise both mistaken identification and self-defense at trial and do better than if I were to raise one or the other. Why? Your attorney has to relate to the jury. Your attorney has to be viewed as credible by the jury, and your attorney has to present a counter narrative to what the prosecutor is putting up for the trial. If your lawyer gets up there, the argument would have to go like this: my client was misidentified, but if you think the identification is proper, my client acted in self-defense. Now, if you're on the jury, you're like, what is going on? It's one or the other. But I don't think you can successfully raise misidentification and self-defense and do better at trial than if you were to raise one or the other. With that said, you can raise multiple defenses at trial if they're consistent with one another. For example, if your defense is I was defending myself, self-defense, and I was defending others, which is defense of others, this all falls under the same defense theory. You acted, but your actions were justified because you were protecting yourself and because you were protecting others. So in that situation, I think it's fine and it's great if you could raise both self-defense and defense of others. But I think you get into just problematic territory if you try to go misidentification and self-defense.